number 24C17.
You may be seated. Okay. Are there any preliminary matters, or do we need to begin with opening statements?
Yes, Your Honor. The plaintiff has a few preliminary matters we'd like to attend to.
Okay,
First, may we enter our appearances?
you may.
Good evening, Your Honor. My name is Russell Howard, and today I'm joined by my co-counsel, Mr. Kovnir Magell,
Good evening, Your Honor.
and Mr. Kenneth Royer. Good evening, Your Honor.
Good evening.
Together, we represent the plaintiff, Mr. Lee Jasper.
Thank you.
Next, what is Your Honor's preference on asking permission before approaching opposing counsel, the bench, and the witness stand? Should we ask permission each time, or should we approach freely?
You may ask permission and then approach the witness.
Yes, Your Honor. And we're here because of a negligence claim concerning an incident that occurred in Jinks County Fair Rodeo. To expedite trial, the parties have stipulated certain facts. May I approach the bench with a copy of these stipulated facts, since these have already been shown to opposing counsel?
You may. Thank you.
And the plaintiff offers these stipulations into evidence pursuant to Rule 33.
Wonderful. They will be admitted into evidence.
Yes, Your Honor. And I noticed there's a podium in Your Honor's court. Consistent with Rule 36, may we have permission to move freely and deliver our speeches and examinations from the well of the court rather than the podium?
You have permission to move about the well.
With that, Your Honor, the plaintiff is ready for trial.
Thank you. Any matters for the defense?
Yes, Your Honor. First, may I introduce myself and my co-counsel?
Yes, please.
Good evening, Your Honor. My name is Manhattan Thuin. To my left is Miss Sarah Grippo.
Good evening, Your Honor.
Good evening.
And to her left is Miss Adley Ogles.
Good evening, Your Honor.
Good evening.
We represent the defendant, Ms. Reese Witherfork, in this case.
Good evening, Your Honor.
Good evening. Thank you.
And we do have a couple of preliminary matters that we would like to address.
You may proceed.
Now, the first is drawing the court's attention to Stipulation 10, which reads that all exhibits in this case have been agreed upon as authentic.
Wonderful. Thank you.
I would also like to ask, as we have a couple of witnesses in this case who might be qualified as experts, would you like us to formally tender them before the court?
I think that would be appropriate. Yes.
Thank you, Your Honor. And with that, the defense is ready to proceed.
All right. We'll proceed with opening statements then.
Yes, Your Honor. May it please the court, defense counsel, and members of the jury. Greed over need. This is a case about a defendant who put her greed for corporate profit over the need for public safety. It's August 24th of last year, inside the Jinks County Fair Rodeo ring. A young bull rider completes his ride, checks to ensure the bull is safely corralled, and triumphantly lifts his hands. The crowd roars. But this rider's triumph is about to turn to a tragedy, because the biggest threat to this rider's safety, it's not the bull. It's an unruly spectator named Coyote Smith who's fighting in the stands. You see, what the rider doesn't know is that Mr. Smith is about to hurl a metal chair into the arena that will knock him unconscious. What the rider doesn't know is that the rodeo's owner was warned by law enforcement just hours before that Mr. Smith and his heated rival were going to get into a fight. And what the rider doesn't know, what he couldn't know, is that the rodeo's owner laughed at this warning because she was more concerned about making money. And that's why we're here today, because the rodeo's owner put her greed for corporate profit over the need for public safety. Good evening, members of the jury. My name is Kavnir Majel, and I represent the rider injured by that metal chair, Lee Jasper. Lee's only 28 years old and was once a rising star on the bull riding circuit. But Lee can't ride anymore because the event I just described left him with a traumatic brain injury. Lee is here, but he cannot testify because his injuries stole much more than his bull riding abilities. A medical doctor will explain that Lee can no longer speak plainly or even remember things from a few hours ago, which is why Mr. Jasper has sued the defendant, the rodeo's owner, Miss Reese Witherfork, for negligence, for allowing Coyote Smith to attend that night after being warned that he was going to get into a fight. During trial, it is our burden to prove that it is more likely true than not that the defendant acted unreasonably when she ignored this warning, and that this unreasonable action caused Mr. Jasper's injuries. We will meet this burden by proving 3 facts. Fact number 1, the defendant was warned there was going to be a fight. Fact number 2, the defendant ignored this warning to make more money. And fact number 3, Coyote Smith's actions caused Mr. Jasper's injuries. But let's take those one at a time. First, Ms. Witherfork's knowledge. A deputy sheriff will take the stand and tell you that when he saw Coyote Smith in the crowd, he located and warned the defendant and told her that a fight was going to happen. Because not only was Coyote Smith unruly and aggressive by his very nature, but his heated rival was also in the stands. Fact number 2, the defendant's failure to act. You will learn that when the defendant learned of this warning, she shrugged her shoulders, laughed, and said that if she kept out people who might start a fight, her business would lose too much money. And finally, Mr. Jasper's injuries. A medical doctor will testify that in his professional medical opinion, it was the chair's impact and not another rodeo event that caused my client's injuries. All of this is why at the end of trial, my co-counsel, Mr. Kenneth Royer, will ask you to find the defendant liable for negligence because she put her greed for corporate profit over the need for public safety. Thank you.
The defense may proceed.
Yes, Your Honor. Now, there's way more to this case than what counsel just told you. You just heard that on August 24th, 2024, Lee Jasper was hit in the head by a metal folding chair. But what if I told you that Lee Jasper suffered a different head injury just a month earlier? What if I told you that this earlier head injury caused all the same symptoms? And what if I told you that with this earlier head injury, Lee Jasper waited a full month before seeking any sort of medical attention? And when he finally did go to the doctor, they said, "Lee, we should probably take a CT scan of your head to rule out a brain injury." Surely, if you knew all of that, you'd want to know what that CT scan would have shown. Lee Jasper didn't. He turned around and he walked out against medical advice. For that reason, and for many other reasons, the plaintiff only got half the story. It's easy to tell half the story when the whole story will cost you. Now, everyone here today agrees that Lee Jasper was hurt, and no one is here to make light of his injury. But how it happened, when it happened, and who's at fault, that's where we part company. And because Lee Jasper decided to file a lawsuit and come to court today, those are the questions that must not just be answered, but proven by them. Today, the burden of proof sits squarely on this table. But today, when you ask yourself 3 basic questions, you'll see the full story. And you will watch their case crumble. So the first question. Can we really say that Reese Witherfork acted unreasonably? Or put another way, should it have been on her to predict that some guy was going to show up to a rodeo, get angry, get into a fight, throw a chair, and injure a bystander? Today, you're going to meet Reese Witherfork. And when it comes to running a business, she's no amateur. She owns and operates several successful local businesses. And when she had a dream of bringing the Jinks County Fair Rodeo to town, her first priority was making it safe. She vetted and hired a high-grade security team from across the country, and because of that, her standard of safety was not only reasonable, it was exceptional. But not even the most fireproof safety measures can prevent every single accident, and that's not what the law requires. What the law does require is that somebody not get a free pass on their own actions just because they sue someone for negligence. And that brings us to our second question. How reasonably did Lee Jasper act in ensuring his own safety? Today, you're going to hear from another bull rider who toured the country with Lee Jasper. And you'll learn that before the Jinks County Fair Rodeo, Lee Jasper was thrown off a bull, violently hit his head against a metal gate, and was knocked unconscious. But you'll also learn that despite showing symptoms of a brain injury for over a month, it took him a month to go to the doctor. And when the doctors told him they needed a CT scan to rule out a brain injury, what was his response? Oh, well, I'm sorry, I've got a writing practice that I just can't miss. And he turned around, and he walked out against medical advice. No diagnosis, no CT scan, no full story. It's easy to tell half the story when the whole story will cost you. And that brings us to our third question. That brings us to our third witness. Today, you're going to hear from a neurologist who specializes in sports-related injuries who evaluated Lee Jasper. And he'll tell you it wasn't a close call. You'll learn that unlike the first head injury, there was a CT scan of the second injury. And for Lee Jasper's symptoms to have even made sense, what that CT scan would have shown was swelling or bleeding in the brain. But there was neither. So that's their case. Instead of getting the whole story, the plaintiff was satisfied with only bringing you half of it. And for that reason, at the end of today's trial, we ask that you find Reese Witherfork not liable. Thank you.
Is the plaintiff ready to call their first witness?
Yes, Your Honor. The plaintiff calls Mr. Sage Hamilton.
Mr. Hampton, you may come forward, and we will presume that all witnesses have been sworn.
Your Honor, before I begin, may I set up an easel in the well for a demonstrative I will later reveal?
You may.
Is here all right, Your Honor?
It's fine with me.
May I proceed?
You may.
Good evening, Mr. Hamilton.
Good evening to you, too.
Will you please state your full name and spell your last name for the record?
Name's Sage Hamilton. You spell that Hamilton.
Where are you from?
I'm a New Yorker by birth, Queens to be exact, but I'm a cowboy at heart. You see, my dad, he moved us down to Tennessee when I was a youngster, and so mostly grew up in Salem. Well, one day, my dad, he brought me and my cousin, Vinny, down to the rodeo. And I loved it so much, I never left Tennessee.
What do you do for a living?
I'm a barrelman on the professional rodeo tour.
What is a barrelman?
You know, a barrelman, man in the can. Some folks call us rodeo clowns. We're the guys with the face paint and the big steel barrels, keeping the riders safe, you know?
For those of us who maybe haven't been to a rodeo recently, can you explain how your job works?
Sure. So you got the riders, right? And they're the ones on the bucking horses or the bulls, but whatever animal they're riding, when they get bucked off, that's where we come in. We get our barrels in between the riders and the animals to keep them safe, you know? But I never would have thought I'd have to watch out for flying chairs, for the love of Mike.
Is your job dangerous?
Dangerous? Is a matador's cape red? They don't call it the most dangerous 8 seconds in sports for nothing. I mean, my ma used to say, there's a thin line between bravery and idiocy. And us barrelmen, we've erased that line.
So let's turn to why you're in court with us today, Mr. Hamilton. Where were you on the night of August 24th of last year?
Okay, so August 24th. I was at the James County Fairgrounds, just south of here, and that was the night of the big incident where Lee Jasper got hit with a chair.
Who is Lee Jasper?
He's a bull rider. One of the best up-and-comers on the tour. Or at least was, until he got hit by that chair.
Did you see what happened to Mr. Jasper?
Absolutely. I mean, I was in the ring with him. I saw it with my own eyes.
So set the scene for us. What was Mr. Jasper doing before he was hit by the chair?
Oh, before. It's like this. He had just gotten off the bull after one of the greatest rides I'd seen in a long time. I mean, he went 9 seconds, 8 to get the points. It was, as barrelmen call it, incredible. It was unbelievable. I mean, the crowd was going wild. It was electric. It was amazing.
What happened after the ride?
He dismounts, and us barrelmen, we do our job. We get the bull back in the pen, right? That's when I turn around and I see a chair go flying at his head.
I'd like to orient the jury. Would you recognize a diagram of the Jinx County Fairgrounds arena if you were to see it?
Yes, sir, I would.
Your Honor, I'm showing opposing counsel permission to approach opposing
may.
counsel with Exhibit A. Permission to approach Mr. Hamilton with.
You may.
Yes, Your Honor. Would Your Honor like a copy?
Sure.
Permission to approach.
You may. Thank you.
Mr. Hamilton, what is Exhibit A that I just handed you?
It's a map of the Jinx County Fairgrounds Rodeo Arena.
Does Exhibit A accurately reflect the fairgrounds as you best remember it?
To my knowledge, yes, sir, it does.
Your Honor, the plaintiff offers Exhibit A into evidence.
Exhibit A will be admitted into evidence.
And permission to display an enlargement of Exhibit A for the jury?
You may.
Mr. Hamilton, if I were to give you a marker, would you be able to show this jury where you were located on the night of August 24th?
Yes, sir, I could.
Your Honor, permission for Mr. Hamilton to step off the stand?
He may.
There's a marker.
Thank you, sir.
Where were you on the night of August 24th when you saw Lee Jasper be hit by the chair?
Okay, yes, sir. I was over here in front of Section C, right in the middle. I had just gotten the bull back in the pen, right, and I walked over the bleachers to see what was going on.
Will you please mark where you were located with your initials?
Yes, sir.
And where was Mr. Jasper?
Well, it's already been marked here with a red X. Again, he'd just gotten off the bull. And I'll tell you once, I'll tell you it again. It was an incredible ride. Amazing. And he was walking towards the exit to, leave the arena.
You said Mr. Jasper was hit by a chair. Where did that chair come from?
Okay. So, I'm looking up into Section A, right? And I see these two fellows on right about here. And they're just giving each other the business, right? And then out of nowhere, one of them grabs a metal folding chair and often hurls it at the other. Except his aim wasn't so good. It goes flying over the first guy and hits Mr. Jasper square in the head. And it hit him so hard, I think even the bulls were surprised.
Could you see the two arguing men and Mr. Jasper clearly?
Absolutely. I mean, it's about 50 yards away, right? But I can see it crystal clear.
Thank you, Mr. Hamilton. You may take your seat.
You ain't talking about it.
Yeah, thanks. Mr. Hamilton, how did Mr. Jasper react after being hit in the head by the chair?
He didn't. I mean, he just fell to the ground. He was knocked out cold.
What do you mean when you say knocked out cold?
I mean, he was totally unconscious.
Your Honor, I'm permission to approach opposing counsel with what's been marked as Exhibit B.
You may.
Permission to approach Mr. Hamilton.
You may.
Would Your Honor like a copy?
Yes, please.
Permission to approach.
You may. Thank you.
Mr. Hamilton, what is Exhibit B that I just handed you?
It's a photo of the green metal folding chair that hit Mr. Jasper lying in the arena.
Does Exhibit B accurately represent the chair as you best remember it?
Yes, sir. I'd say so.
Your Honor, the plaintiff offers Exhibit B into evidence.
Exhibit B will be admitted.
And permission to publish copies to the jury.
You may.
Hopefully these are enough. Mr. Hamilton, let's turn back to the two arguing men in the stands. Did you recognize either of the two arguing men?
Yes, sir. I know both of them. It was Kylie Smith and River Jenkins.
How did you recognize them?
I'd seen them both on the tour before.
Had you ever seen them interact prior to August 24th of last year?
I mean, absolutely. These two guys, nearly every single time I see them, there was a fight. I mean, like cats and dogs, these guys were always fighting, nearly always fighting.
When you say fighting, do you mean arguing?
No, I don't mean arguing, but what, like, I mean actual fighting.
I'd like to talk about the atmosphere at the defendant's rodeo. Have you attended the JCF rodeo in past years?
Yes, sir, every year.
Have you ever seen fights occur at the JCF rodeo in the past?
Yes, sir. I mean, I'd say a couple times a year.
Thank you, Mr. Hamilton. I have no further questions, Your Honor.
Thank you. Cross-examination?
Yes, Your Honor. Before I begin, may I set up an enlargement in the well of Exhibit A?
You may.
Would you like me to take down our version of Exhibit A?
Yes, please. Thank you. All right, now, Mr. Hamilton, you obviously have a lot of experience in your career.
Yes, sir, ton.
So
Yes,
you've
ma'am. I'm so sorry. I'm so sorry.
No worries, no worries. So you've seen lots of bullfights.
Yeah, I'd seen lots of bull rides.
Bull riding,
Yes,
my
ma'am.
apologies. And you know, as a professional in this field, bull riding is extremely dangerous.
It can be.
Right, so let's talk a little bit about what bull riding is. So it starts when the bull rider gets on the bull.
Yes, ma'am. I'm sorry.
Right, the bull is contained inside a chute at this point,
Yes, ma'am.
but it's agitated, it's angry.
Most of the times. Yes, ma'am.
The bull is then released from the chute,
Yes, ma'am.
and it starts bucking and rearing violently.
Yes, ma'am. That's
Do-
exactly right.
Right, doing everything that it can to knock the bull rider off.
Well, I don't know what the bull's going through the bull's head, but it's pretty mad.
Well, certainly, it's jumping around trying to get the bull rider away from it.
That's correct. I mean, I don't know what's going on in its head, but that's right.
Right, and the ride ends when the bull rider is effectively thrown off the bull.
Or they stay on, but yes, that is correct.
And that's where you come in.
Exactly.
Right, your job is to distract the bull from the bull rider.
I distract them. I also can get my barrel in between the riders and the bull if the bull is angry and goes towards the rider. You know, it's very dangerous when the bull, 2,000 plus pounds, steps on a rider. That can be very problematic for someone's stomach or something. And, when I stop that, we put a barrel in between. They step on the barrels of the man, right?
Yeah, certainly. So your job is to intervene as soon as possible so the bull rider can get out of the ring.
Correct.
and that's because bull riding is extremely dangerous.
It can be, that's right.
Now, I'd like to talk a little bit about the chair that you saw thrown at Lee Jasper. Now, you've seen a picture of the chair, and Exhibit A is already in evidence, the map of the arena.
Yes, ma'am.
And I believe you have a copy of it with you on the stand.
Which one?
Exhibit A, I apologize.
Yes, ma'am, I do.
I'd like to talk a little bit about where everything was happening in relation to each other. So the red
Your Honor,
X,
may I move to see the demonstrative one?
You may.
the red X is where Lee Jasper was standing.
Okay, I'm assuming we're talking about the same, this one?
Yes, Exhibit A.
Okay, I just can't see that. The red X is where Lee Jasper was saying, yes, ma'am, that's correct.
Right, and you were somewhere in C of the stands. They're divided into 4 parts. You were in C.
I was not in C, no.
You were 50 yards away.
I was 50 yards away from Lee Jasper.
Right, from Lee Jasper, near where Section C was.
Yes, I was near Section C. I was still in the ring.
Right, you were in the ring 50 yards away, near Section C.
That's correct.
Right. Now, this chair was thrown from somewhere in Section A,
That's correct.
about 5 rows back from the middle,
Yes, ma'am.
and that was 50 feet away.
No, ma'am.
Mr. Hamilton, so let's look at the distance really quick here.
Objection, Your Honor. Opposing counsel is using sticky notes to indicate locations on the map to where Mr. Hamilton is referencing on his testimony. I'd object that this is more prejudicial than probative because opposing counsel is not asking Mr. Hamilton where these locations were and is signaling on the demonstrative where they were with the sticky notes.
May I respond, Your Honor?
You may respond.
So during cross-examination, we are not supposed to ask open-ended questions, so I couldn't ask Mr. Hamilton, well, where were you standing? The question is supposed to be, you were in Section A, you were in Section C. And so pointing that out to the jury so they can keep track of all this information isn't prejudicial in any way, it's just cross-examination.
Any rebuttal?
Yes, Your Honor. I believe opposing counsel can ask open-ended questions during cross-examination. It may not be standard practice, but limited use is permitted as well. Additionally, this is still more prejudicial than probative because opposing counsel can elicit the same testimony without putting the sticky notes on Exhibit A.
On the basis of the objection of prejudicial more than probative, the objection is overruled.
Yes, Your Honor.
Now, Mr. Hamilton, you know that there's 3 feet in a yard. My apologies.
Yes, ma'am, I do know that.
Right. And the distance between A and C is about a third.
A third of what?
A third. So where Mr. Jasper was standing in relation to Section A versus where Mr. Jasper was standing in relation to Section C is about a third.
I mean, I'm no math guy, but I mean, that could be right.
Sure, you can at least agree with me that it's a much smaller distance.
Yes, ma'am, that's right.
Right. And now the chair was thrown by somebody standing in Section A
Yes, ma'am, that's right.
who was aiming at the person next to him.
I assume so. I mean, they're more like directly like this. See, the chairs are actually pretty far apart, and they were yelling at each other across. So he threw it towards the arena, even though they were still in the same section. He threw it down towards the arena, and that's how it hit Mr. Jasper.
Well, certainly, but they were sitting in the same section, close enough where they could be talking to each other.
That's correct.
And this person who had the chair thrown at them ducked,
That's correct.
so
Yes.
the chair went flying over them
That's correct.
50 feet to where it hit Lee Jasper.
It was not 50 feet. I don't know the exact number, but I don't know the exact number. I mean, it could have been 50, it could have been, I think it was probably closer to something like 30, because, I was 50 yards away, and I'd say it's probably about it. I mean, I don't know the exact number, ma'am, and I can't give you that number, because I didn't have a measuring tape. But they were pretty close to each other, and I mean, he threw it pretty hard.
Well, certainly, and I mean, let's go with 30 feet. 30 feet's a lot farther apart than you and I am.
That's correct.
It's farther than you and that wall.
That is correct.
It's a pretty significant distance to be throwing a metal chair at another person.
I mean, I'd say it's probably about as far as that wall is to me. And, I mean, I'm not speaking in general terms here, but I can throw a chair that far.
All right, Mr. Hamilton. No further questions, Your Honor.
Okay, thank you. Any redirect?
Yes, Your Honor. Mr. Hamilton, opposing counsel mentioned the danger that bull riders know when they get on the bull. In your experience in bull riding, when you get on a bull, do you assume the risk that someone will throw a chair at you?
Absolutely not. In all my years of, being a barrelman, and I've seen lots of rides all across the countries with different audiences, I ain't never seen someone throw a chair at another man.
Thank you, Mr. Hamilton. No further questions, Your Honor.
All right, the witness is excused. Counsel, who's your next witness?
Yes, Your Honor, the plaintiff calls Sheriff Deputy Skylar Parker.
Deputy Parker, you may come forward.
May I proceed, Your Honor?
You may.
Good evening, Deputy Parker.
Evening, sir.
Will you please state your full name and spell your last name for the record?
It's Skylar Parker, spelled P-A-R-K-E-R.
What do you do for a living?
I'm a deputy sheriff with the Jinx County Sheriff's Department, badge number 83231.
What are some of the job responsibilities of a deputy sheriff?
I handle routine patrol, public safety, and general law enforcement throughout Jinx County.
And how long have you worked in the sheriff's department?
I joined the force in 2019, so we'll be at 6 years come this May.
And did you receive any special training in law enforcement prior to joining the force?
Yes, sir. I graduated from the police academy in 2019, just prior to receiving my commission.
Now, Deputy Parker, I want to move on and talk about this case. How are you involved?
I attended the Jinx County Fair Rodeo on August the 24th of last year. That was the night when the bull rider, Mr. Lee Jasper, was injured when a chair was thrown from the rodeo stands by a man named Coyote Smith, the chair striking Mr. Jasper in the head.
Were you on duty that night?
No, sir, not that night. I enjoy a good rodeo.
Did you witness Coyote Smith pick up the chair and actually throw it?
No, sir, not personally. However, I did try to prevent Coyote Smith from hurting anyone that night.
What do you mean by that?
Well, prior to the incident, I saw both Coyote Smith and River Jenkins seated in the rodeo crowd. And when I realized that both men were in attendance, I immediately located the owner of the rodeo, Miss Reese Witherfork, to warn her of the danger.
So what did you tell the defendant?
I told her of my concerns and that there was going to be a fight.
Now, you just mentioned some concerns. Do you mind elaborating to the jury as to what these concerns were?
Certainly, sir. I told the defendant that, firstly, River and Coyote were together in the stands, and that they were involved in an ongoing dispute over a particular bull named Consume Additional Poultry. Additionally, I stressed to the defendant that Coyote was a ticking time bomb, really, because of some of the things he'd been involved in the past. And I stressed to her also that it's been my experience in law enforcement seeing how repeated minor incidents can lead to violent behavior. I said, look, Reese, you know how River and Coyote feel about each other. I know how River and Coyote feel about each other. Everybody knows how River and Coyote feel about each other. There's going to be a fight.
Deputy Parker, did the defendant express any disagreement with you when you said to her that she knew how River and Coyote felt about each other?
No, sir, she did not.
And just to be clear, when you issued this warning, was that before or was it after the chair had been thrown that hit Mr. Jasper?
These warnings were before, sir, before that.
How did the defendant react to your warning that there was going to be a fight?
Well, she laughed, sir.
I'm sorry, she laughed?
Well, yes, sir. When I told the defendant that River and Coyote were together in the stands and that there was going to be a fight, She shrugged her shoulders and laughed at me.
Did the defendant attempt to remove Coyote Smith from the rodeo?
Not that I saw, sir.
Did the defendant ask you what section of the stands the two men were in?
She did not.
Did the defendant ask you why you believed that there would be a fight?
No, sir.
Deputy Parker, did the defendant say anything in response to your warning other than laughing?
Well, yes, sir. She put her arm around me and she said, look, Skylar, take a look at all these rodeo stands over here and how packed they are today. She said, if I kept out anyone who might start a fight, this business of mine, it wouldn't survive because I'd lose too much money.
Now, Deputy Parker, you mentioned that the defendant said anyone who might start a fight, and I just want to be very clear for the members of the jury. Did you say to the defendant that there might be a fight, or did you say something else?
Oh, no, sir. I told the defendant that with River and Coyote together in the stands, there was going to be a fight. No ifs, ands, or buts about that part.
Thank you, Deputy Parker. Your Honor, I have no further questions.
All right, thank you. Cross-examination?
Yes, Your Honor. Deputy Parker, you're a 5-year sheriff's deputy.
That's correct.
Before that, you were a mall cop.
Correct again, ma'am.
Before that, you were a hall monitor.
Yes, ma'am. Hall monitor was in high school.
All right, let's talk a little bit about today's case. You know Wiley Smith.
I have known Coyote, yes.
He's the person that threw the chair from the stands at Lee Jasper.
That was my understanding based off the interviews of several eyewitnesses at the JCF rodeo. However, again, I did not witness that personally.
However, Deputy Parker, you've known Coyote Smith for quite some time now.
That's correct, ma'am. Since high school.
Yeah, you went to high school with him.
Correct.
And since then, you've run into him multiple times.
Yes, ma'am.
According to you, he has a reputation around town for being a hothead.
That's correct, ma'am. Coyote's had an extremely unruly and, frankly, uncontrollable and explosive personality since high school.
Now, Deputy Parker, that's the word you used. You called him a hothead, right?
That's correct.
So it's crucial that this jury understands exactly what you meant by that. By hothead, you said that he does not shy away from a verbal argument.
That's correct.
By hothead, you said that he even sometimes instigates verbal arguments.
Often does so, yes, ma'am.
But Deputy Parker, before August 24th, you can't recall a single time where Wiley Smith had been physically violent.
Not to my personal knowledge, no, ma'am.
That's right, because before August 24th, there's no proof that he had been physically violent.
I can't speak to proof of that existing, ma'am. I can only tell you that I have no personal knowledge of it if it exists.
Now, you actually kind of have a personal relationship with Wiley Smith.
I'm not sure what you mean, ma'am.
You've arrested him 3 times?
I have arrested Coyote Smith 3 times for various disturbing the peace charges congruent with his aforementioned behavior.
And after each of those arrests, the charges were dropped.
The charges, ma'am?
The charges didn't stick, he wasn't convicted.
Well, the charges were not dismissed, no, ma'am.
But he wasn't convicted of the things that you arrested him for?
Well, the cases were eventually dismissed, yes, ma'am. The grand jury did not fail to indict Mr. Smith. Why those cases were dismissed or at what point along their track, whether they were part of a collective plea deal or something of that nature, I have no knowledge of that, ma'am.
Now, Deputy Parker, you don't really like Wiley Smith.
I wouldn't agree to that, ma'am.
He's actually filed a formal complaint against you for police harassment.
I understand Mr. Smith has filed the complaint. However, I don't imagine it will go anywhere, as I have never and will never, of course, harass a citizen of Jinx County during my time as a deputy sheriff or as a sheriff.
Now, Deputy Parker, somebody who's running for sheriff, it doesn't help to have that police harassment charge.
Considering how apparently false the allegations are, ma'am, it's not an enormous consideration of mine.
And so if this jury, who is part of the group that might elect you as sheriff, were to ask you, hey, what's the first thing that you're going to do when you're elected sheriff? You'd tell them, put Wiley Smith in jail.
That's exactly right, ma'am. I plan to place Cowdy Smith under arrest with the charge of battery for his actions on August the 24th of last year at the Jinx County Fair Rodeo.
Now, Deputy Parker, I'm quoting from your statement here. You don't say put him in jail for this, that, and the other. You say put Wiley Smith in jail, period, correct?
Yes, ma'am, for that reason that I just mentioned.
Thank you. No further questions.
Any redirect?
No redirect examination, Your Honor.
All right, thank you, Dr. Parker, or Deputy Parker, excuse me.
Not quite yet.
Plaintiff, do you have another witness?
Yes, Your Honor. Plaintiff calls Dr. Dahl Carter.
Dr. Carton, you may come forward.
May I proceed, Your Honor?
You may proceed.
Good evening, Dr. Carter.
Good evening.
Would you please state your full name and spell your last name for the record?
Dahl Edward Carton. Carton spelled C-A-R-T-O-N.
Where are you from?
I'm originally from the Shaanxi province of China, but for primary and secondary school, I attended an English immersion program. After that, I moved stateside for university in 1994 and, well, I never left.
What do you do for work, Dr. Carter?
I'm a medical doctor. My practice is located here in Salem, just across town.
Do you specialize in a particular field of medicine?
I do. I specialize in neurology.
What is neurology, doctor?
Neurology is the subspecialty of medicine that deals with diseases of the brain, spinal cord, and nervous system. You know, the brain is such a special organ. It controls and coordinates everything that we do.
What does your practice involve, Dr. Carter?
My practice focuses on diagnosing and treating patients with cognitive impairments. So when there's a problem, patients come to me and ask, why? Why is this happening? And that's the question I answer for them, and then I treat them.
Doctor, before we dive into your analysis of Mr. Jasper's conditions, I'd like this jury to hear about your credentials. You mentioned that you moved to the U.S. for education. Tell us about that education.
Certainly. I hold a Master's of Public Health degree from Salem State University. I attended medical school and completed my residency at the University of Salem Medical Center.
How long have you been a neurologist?
I have 15 years of clinical and surgical experience.
Are you board certified in the field of neurology?
I am.
Your Honor, the plaintiff tenders Dr. Dahl Carton as an expert in the field of neurology under Rule 702.
Dr. Carton will be considered, is there an objection?
No, Your Honor.
Thank you. He will be accepted as an expert in neurology. Thank you.
Yes, Your Honor. Doctor, let's turn to your work in this case. Why are you in court with us today?
I was hired by a patient named Lee Jasper, who retained me to evaluate and diagnose the cause of certain neurological conditions that he was suffering from.
Did you have sufficient facts and data to diagnose the cause of Mr. Jasper's neurological conditions?
I did. I reviewed Mr. Jasper's medical records, history of traumatic incidents, examining his current neurological symptoms, all witness statements and exhibits, as well as relevant medical literature on foreign accent syndrome and traumatic brain injury.
Would you recognize a copy of those medical records if you saw them in court today?
I would.
Your Honor, may I approach opposing counsel with copies
may.
of Exhibits F and G?
You may.
May I approach the witness?
You may.
Would Your Honor like copies?
Sure. Thank you.
Dr. Carton, do you recognize Exhibits F and G I just handed you?
I do. These are Mr. Jasper's medical records from August 17th and August 25th, respectively, that I reviewed.
Do those appear to be fair and accurate copies of Exhibits F and G as you reviewed them?
They do.
Your Honor, the parties have stipulated that Exhibits F and G are business records pursuant to 8036. With that foundation, the plaintiff offers Exhibits F and G into evidence.
Exhibits F and G will be admitted into evidence.
Doctor, did you apply reliable principles and methods in reaching your conclusion?
Of course.
And did you reach that conclusion to a reasonable degree of medical certainty?
I did.
Tell the jury what you concluded.
I concluded that the cause of Mr. Jasper's traumatic brain injury and foreign accent syndrome was the metal folding chair that impacted his head on August 24th of last year at the Jinx County Fair Rodeo.
What is a traumatic brain injury?
Traumatic brain injury is, well, that's what it sounds like, really. It's an injury to one's brain, typically caused by a traumatic external blow to the head. The most common symptom is memory loss.
And what about a foreign accent syndrome? Can you tell the jury what that means?
Certainly. Foreign accent syndrome is a much rarer condition, but it's also caused by an acute injury to one's brain. A person suffering from foreign accent syndrome experiences changes to their speech patterns, their cadence, their intonation. Put simply, they lose the ability to speak plainly. And the result of those changes is that the patient often seems as if they've developed a foreign accent, hence the name foreign accent syndrome.
What led you to your conclusion, Dr. Carter?
Primarily two things: the nature of foreign accent syndrome and the timing of Mr. Jasper's neurological symptoms.
I want to ask about both of those things, Dr. Carter. But let's start with the first thing you mentioned, the nature of the foreign accent syndrome. Why is that important?
Well, when a patient suffers from foreign accent syndrome, the alterations to his or her speech manifest very soon after the trauma. We're not talking about a condition where that patient experiences trauma to the brain, goes on to speak normally for a few weeks, and then experiences alterations to their speech.
How, if at all, did that affect your evaluation in this case?
Well, I knew that Mr. Jasper was a bull rider, so the first thing I evaluated was whether he'd experienced any recent head trauma prior to the manifestation of his speech problems.
Based on the plaintiff's medical records, had he experienced head trauma?
Indeed, on 2 occasions. He suffered a blow to the head on August 24th at the JCF Rodeo when that metal chair was thrown from the crowd and struck his head. He also hit his head on a metal gate at a different event 5 weeks earlier when he was thrown from a bowl in Wichita, Kansas.
So, doctor, if there were 2 blows to Mr. Jasper's head, how were you able to pinpoint which of those 2 blows led to the plaintiff's neurological injuries?
Yes, well, that's where the timing of Mr. Jasper's symptoms comes in. The alterations to his speech only appeared after the metal chair incident, not the incident 5 weeks earlier that occurred in Wichita, Kansas.
How do you know this?
I reviewed Mr. Jasper's clinical paperwork.
Your Honor, permission to display an enlargement of Exhibit F that was already in evidence.
You may.
And permission for Dr. Carter to step off the stand to interact with this enlargement.
He may.
Dr. Carter, I'm handing you a marker. So, doctor, is this the medical record you reviewed from before the incident?
This is that record from August 17th of 2024.
Just to be clear for the jury, was this record taken before or after the incident at the Jinx County Fair Rodeo?
Before, 1 week before.
So, doctor, why is this document important if it was taken 1 week before the incident at the defendant's rodeo?
Because it details which symptoms existed prior to the chair incident, but more importantly for this case, which symptoms were not present. As you can see there, at the time, Mr. Jasper developed nausea, blood vision, and memory loss. There are also no mentions of any speech problems or speech alterations.
So how does that compare to the plaintiff's symptoms after he was hit in the head with the chair?
After the chair incident, Mr. Jasper began to experience a number of symptoms that were not present prior. He lost the ability to play. He struggles with the memory, even the most basic tasks, for more than a few minutes. He suffers from blurred double vision, constant nausea, and excessive fatigue, all of which are not present prior to the chair incident.
So, doctor, how did the onset of significant new symptoms after the chair incident affect your conclusion in this case?
It told me that the chair incident caused those conditions.
Thank you, Dr. Carton. You may take your seat. I have no further questions, Your Honor.
All right, thank you. Cross-examination.
Yes, Your Honor.
Would you like him to take down the mic?
Is it the full exhibit?
Yep.
In that case, if you would leave it up, that would be wonderful. Thank you. Now, Dr. Carton, you're aware that Lee Jasper has been treated for multiple different head injuries by multiple different physicians.
Yes, that is correct.
You are not one of those treating physicians.
No, I am not.
So, in other words, Lee Jasper has never been your patient.
No, he is not.
What he is today is your client.
Correct.
In other words, Lee Jasper and his counsel are paying you to be in court today
Correct, yes.
and to tell this jury your opinion.
Correct, yes.
All right, so let's talk about that opinion. Now, it is your opinion that Lee Jasper's current symptoms were caused by the head injury that he sustained on August 24th.
That is correct, yes.
You're going as far as to say that that was the sole cause.
Correct, because of the appearance of those new symptoms after that chair incident that did not exist prior.
You're going even further, Dr. Carton, to say that there is no doubt in your mind that that is the sole cause.
Correct, I achieved that conclusion to medical certainty.
In other words, there is no reasonable possibility that any of Lee Jasper's previous injuries could have caused any of his current symptoms.
I'm sorry, could you repeat that, please?
Yes, doctor, you're saying that there is no reasonable possibility that any of Lee Jasper's previous injuries could have caused the symptoms that he is displaying now.
That is correct, yes. There is a possibility, though it is my conclusion to a reasonable degree of medical certainty that the chair incident was the sole cause.
All right, let's be realistic with the jury here for a second. Lee Jasper is a professional bull rider.
That is my understanding, yes.
As we already talked about today, bull riding is a dangerous sport.
I'm not sure, I'm not an expert in bull riding, though it seems that it is a bit violent.
A bit violent, notorious for causing head injuries.
Yes, there are generally a number of head injuries associated with bull riding.
And you know that Lee Jasper himself has actually had his fair share of injuries from bull riding in the past.
Yes, a few.
Now, you would agree with me that a hallmark indicator of a traumatic brain injury would be the sort of symptoms that somebody is displaying.
Yes, that is generally correct, yes.
Now, after August 24th, Lee Jasper was exhibiting certain symptoms.
Correct, that were not present prior to the chair incident.
Well, we'll get there in a second, but those symptoms included unconsciousness,
Yes, he was knocked unconscious after the chair incident.
headaches,
Yes, as well.
dizziness,
Yes.
and then witness reports of short-term memory loss.
Yes, as well.
All right, now you're aware that Lee Jasper suffered another head injury just a month prior in July, right?
Correct, yes.
And after that injury, he also started displaying certain symptoms.
Yes, that is correct.
Those symptoms included unconsciousness,
He was also knocked unconscious after that incident.
headache,
Yes, as Exhibit F displays, yes.
dizziness,
Yes, also correct.
and witness reports of short-term memory loss.
No, Exhibit F does not display any memory loss. In fact, it says denies memory loss.
Well, Dr. Carton, I'm not asking you about Exhibit F here. I'm asking you, were there witness reports of short-term memory loss?
Yes, that is correct.
All right. Now, you would agree with me that brain injuries are very serious.
Yes, that is correct.
If someone experiences head trauma and then starts going through symptoms, they should seek medical attention right away.
Generally, it depends on the severity of the certain symptoms. Headaches are pretty common and might not require a medical diagnosis or medical treatment.
I'm going to direct you back to my question. You would say that if someone experiences head trauma and then starts exhibiting symptoms, they should seek medical attention.
Generally, yes.
All right. Now, they certainly should not refuse to seek medical attention, right?
That is correct. That is generally not the right practice.
You would agree with me that it would be unacceptable if they were to go seek medical attention and then leave against medical advice.
Yes, that is not the practice that is generally, commended.
All right, well, let's talk about Lee Jasper's practice here for a second. You have a copy of Exhibit F up on the witness stand with you?
I do.
All right, now if you'll read along silently as I read aloud. It says the date of this walk-in clinic visit was August 17th.
Correct, yes.
Dr. Carton, that was a month after the Wichita, Kansas incident?
That was.
If we drop down here to the assessment section, it then says that based on symptoms, he was recommended a CT scan to rule out brain injury. Did I read that correctly?
You did, yes.
It then says that the patient, Lee Jasper, declined and left against medical advice. Read that correctly?
You did, yes.
All right. Now, Dr. Carton, one thing you can agree with me on is that brain injuries can be kind of difficult to diagnose, right?
Not necessarily, no.
Well,
I disagree
unlike-
with that.
Pardon, you continue.
I'm saying I disagree with that. Brain injuries are pretty easy to diagnose.
Well, unlike bone fractures, where you can, say, pull up an x-ray and point to it, brain injuries are at least more elusive.
No, I disagree with that.
Dr. Carton, would you agree with me that it's common for there to be disagreement among doctors as to the cause of a brain injury?
There is, based off of the different factors that cause that injury.
And that's exactly what we have here in this case between you and our defense expert, Dr. Boone.
Yes, that is my understanding.
Which is why it's very important that this jury get a full picture of what's at stake for you in this trial today. So you're currently in the process of writing a book on foreign accent syndrome, right?
Correct, yes.
And Lee Jasper is your primary subject.
Yes, that is correct.
You thank Lee Jasper for the opportunity to make your dream of becoming a published author a reality.
I was going to write that book regardless of Mr. Jasper's presence. But having a case of such a rare condition so close to me, Mr. Jasper was the prime subject.
Dr. Carton, I'm going to ask you my question again, and I'll need a yes or a no. You thank Lee Jasper for this opportunity.
Yes, as in agreeing to be my subject.
Thank you, Dr. Carton. I have no further questions.
All right, any redirect?
No redirect, Your Honor.
Would you like me to help clear this out of the way?
Thank you, Dr. Carton. You may step down. You are excused.
The plaintiff rests.
All right, thank you. Is the defense ready to call their first witness?
Yes, Your Honor, the defense calls Jess Jones to the stand.
Ms. Jones, you may come to the witness stand.
Goodness gracious.
Please tell us your name.
Good afternoon. My name is Jezebel Louisa Jones.
Miss Jones, where are you from?
Well, I'm proud to say I live here in Salem, but I get to spend most of my time on the road.
Why is that?
I travel a whole lot for work. I'm in a little thing called the live entertainment industry, and I'm always working at a new venue.
What specifically do you do in the live entertainment industry?
What do I do? Well, hun, I'm a professional bull rider.
A professional bull rider?
Yes, ma'am, and darn good one at that. Mind you, I may not ambulate like I used to could, but once you get up on that bull and the crowds are screaming your name, all that matters is whether you can hang on, and well, I'm still one of the best at that.
Miss Jones, let's talk a little bit about why we're here today. Do you know Lee Jasper?
Yes, ma'am, I sure do.
How so?
Well, we used to be friends.
What do you mean you used to be friends?
That means we're not friends anymore.
Well, why is that?
We had a little falling out after his accident. He had the nerve to call me Jezebel Jones, a fake. I'm not even entirely sure what that means, but it really got under my skin. The only thing fake about me are these hips and my knees and... No, never mind. Leave the kid at a point.
Well, what led Mr. Jasper to call you a fake?
Right before it happened, I walked in while Lee was on the phone in our hotel room, and mind you, I wasn't trying to eavesdrop or anything, but I heard Lee say something about hitting the lottery and the farm being saved.
When did you hear him say those things?
On August 28th of 2024, that was about 4 days after his accident.
I'd like to talk now a little bit about your relationship with Mr. Jasper before your falling out. Could you tell us about that?
Well, we were inseparable, like my Uncle Jim in the county jail.
What do you mean?
We were close friends, good friends, and riding partners too, you know. Get real expensive, too expensive, having to travel to all these rodeos and competitions, so I really appreciated having someone I could split hotel costs with.
How did you meet Mr. Jasper?
Well, we met on the circuit. I had a lot of respect for the kid, you know. He was the only rider who could keep up with my pace of life, though it did always bug me that he spent so much time on that phone of his, always sending these goofy pictures to these girls he met on Instabook face.
I'd like to talk now a little bit about yours and Mr. Jasper's bull riding careers. Did you compete together at any events in August of 2024?
Yes, ma'am, we did, in the Jinx County Fair.
Did you compete in any other events that summer?
Yes, ma'am, in July of 2024, we competed at an event in Wichita, Kansas.
How did that ride go for Mr. Jasper?
Well, Lee had a nasty, nasty fall and got knocked right out.
When you say Mr. Jasper got knocked right out, do you mean knocked out of the competition?
No, ma'am, no, ma'am. I mean, for a second, I really thought Lee was shaking hands with the good Lord, but turns out he was just knocked unconscious, but he stayed that way for a good while.
When Mr. Jasper came to, did he receive any medical treatment?
No, ma'am, not immediately at least. Lee refused to go to a doctor, but eventually I said, Lee, honey, you're being plain stubborn. And I convinced him to go in a walking clinic here in Salem.
And during the month that passed between his visit to the walk-in clinic and his accident in Wichita, Kansas, did his behavior change at all during that time?
Well, yes, ma'am, it did.
How so?
Well, for starters, he would complain about these headaches and dizziness and even nausea. And, well, I don't do nausea, but he also started forgetting basic things.
What do you mean?
Well, I'll give you an example. Sometimes we sit in our hotel room and watch a TV show or movie, and we get to the end, and Lee would ask me what happened at the beginning because he just couldn't remember.
Was Mr. Jasper forgetful about anything else?
Yes, ma'am. He also had trouble remembering what cities we were going to next and the dates for events on our schedule.
Now, you did mention that Mr. Jasper eventually went and saw a doctor. Could you remind us when that was?
It was August 17th of 2024.
And was that before or after the Jinx County Fair Rodeo?
A little before.
Well, tell us about the visit.
Well, we went to the clinic, and I stayed in the waiting room while Lee went back with the doctor doing my daily crossword. And not all that much time passed when Lee came out and said we needed to go.
What did you do when he said you two needed to go?
Obviously, I asked him what the doctor said, but he really wouldn't tell me much. He just kept rambling on about how important it was for him to win a few more competitions before the season ended.
Did he explain why?
It was about the money, I suppose, you know. In the rodeo world, we're not paid a lot, but what we are paid is based on how we're ranked.
Speculation. The question that Ms. Ogles asked was, why did he tell you why he left the doctor's appointment? And the witness testified that, I don't know, it might have been for money. She's speculating to the mindset of Mr. Jasper when opposing counsel asked for a statement.
May I respond, Your Honor?
You may.
So the question was specifically asking, what did Mr. Jasper say when asked about why he needed to leave the appointment? And the witness did say that he wouldn't answer, but the only thing he would talk about was money. We didn't say that's exactly why he left the appointment. That's up for the jury to connect the dots on that issue.
Response, Your Honor?
You may.
Your Honor, the witness testified that the reason was for money. And that's speculation to Mr. Jasper's mindset, because she cannot testify to why he left the doctor's appointment if Mr. Jasper did not tell her why.
May I respond?
I'm ready to rule. The objection will be sustained.
Yes,
Thank
Your
you.
Honor.
Motion to strike, Your Honor?
Your motion is granted. The answer will be stricken.
In that case, may I make an offer of proof?
You may.
The This question begins my offer of proof. Did Mr. Jasper explain why he wanted to leave the doctors?
Well, Lee had confided to me that money was a concern at the moment. His family farm was at risk for foreclosure, and I knew he was behind on mortgage payments.
And after this doctor's visit, did Mr. Jasper continue competing?
Yes, sir. Yes, ma'am. We both did exactly 1 week later in the Jinx County Fair. And typically, a serious injury can keep a bull rider from finishing out the season, but that kid insisted that the show must go on.
That question concludes my offer of proof, and I have no further questions.
Thank you. Cross?
Yes, Your Honor. Ms. Jones, I first want to start with something that Ms. Ogles brought up in her opening statement. She told this jury that the reason that Mr. Jasper left that visit at the walk-in clinic was that he said, quote, "I have a riding practice I can't miss." You heard Ms. Ogles say that?
Yes, sir. I was listening during an opening statement.
No, Mr. Jasper did not tell you why he left left that visit, correct?
No, sir. Like I said, once we got in the car, he just rambled on about how important it was for him to continue competing.
And you've been listening throughout trial today, that's correct?
Yes, sir. I've been in the courtroom.
You haven't heard anyone else say that the reason Mr. Jasper left that visit was because he had another riding practice, that's right?
Not yet in the trial, no, sir.
Now, I'd like to shift gears and talk about the phone call you overheard at the hotel. You don't know who Mr. Jasper was talking to on the phone, that's right?
No, sir. I suppose it was his mom or Aunt Jessie, but I can't be for sure.
Whoever it was, you didn't hear anything this other person said.
No, sir, because when you're on a phone call, it's one-sided.
You didn't ask Mr. Jasper who he was talking to or what they were talking about?
No, sir, because like I said, he called me a fake after that, and on top of that, once I walked into the room, he was really quick to put his phone away, which was odd, because he had never done that before.
You testified on direct examination that you thought he said something about hitting the lottery and saving the farm, but you have no personal knowledge of whose farm was being discussed, that's right?
Well, sir, like I mentioned, he had told me that he was behind on mortgage payments, so I assumed it was his farm.
Well, ma'am, from the context of the call you heard, there was no identification of whose farm it was, right?
No, sir. All I knew is he was behind on mortgage payments for his family farm, and in that moment, what I overheard was that the farm had been saved.
Well, you didn't hear Mr. Jasper say anything about the chair incident at the Jinx County Fair Rodeo, that's right?
No, sir, just that he had hit the lottery and the farm was saved.
You didn't hear him say anything about his injuries?
No, sir. Like I said, as soon as I walked in, he was really quick to put that phone away.
You didn't hear him say anything about lawyers or lawsuits, right?
No, sir. Again, he was really quick to put his phone away once I walked in the room.
And just to make it clear, you certainly didn't hear Mr. Jasper say anything about the defendant, Reese Witherford, that's right?
No, sir. Like I said, just hitting the lottery and the farm being saved.
I'd like to shift to something I think you and I can agree about, Ms. Jones. Getting hit in the head by that chair changed the law about Mr. Jasper, that's right?
Well, I know I wouldn't want to be hit in the head with a chair, so yes, sir.
Before the chair incident, you had good times with Mr. Jasper, that's right?
Yes, sir, the best of times.
Before the chair incident, you described the two of you on direct examination as inseparable, that's right?
Yes, sir, we were really good friends.
But after the chair incident, Mr. Jasper wasn't the same anymore, was he?
Well, like I said, I only spent 4 days with him after the accident, and he seemed normal-ish to me. I mean, he seemed fine. He was walking around and talking and everything.
Well, you say he seemed normal, but he went from someone who you had good times with and were inseparable with to someone who said rude and hurtful things to you.
Yes, 4 days after, right after the phone call, that's when he called me a fake, and that's unfortunately when our friendship parted ways.
That's right, he called you a fake after this chair incident at the Jinx County Fair Rodeo.
Yes, sir, and I know it would be hard going to sleep as country as collard greens and then waking up and saying good day, mate, to your reflection, but that's no excuse to call a good friend a fake.
And that wasn't like the Lee Jasper you knew before the chair incident at the defendant's rodeo. That's right.
Well, he certainly hadn't called me a fake before. So yes, sir.
Now, I want to talk about his physical abilities. From what you could see, they changed as well. That's right.
Yes, sir.
Before the chair incident, Mr. Jasper was a talented bull rider. That's correct.
He was incredible. Yes, sir.
Before the chair incident, Mr. Jasper was ranked top 10 in amateur bull riders. That's right.
Yes, sir. I was very proud of him.
And before the chair incident, Mr. Jasper was someone who always competed through physical pain. You'd agree with that?
Well, not always. No, sir. I wouldn't agree with that.
So it's your testimony that he was someone who didn't have the mentality to compete through physical pain?
He surely had the mentality, but I wouldn't say every time he got off my bull he was hurt.
Well, I'm more asking about whether or not he continued riding. He was someone who always competed through physical pain. That's right?
Yes, sir. I knew Lee to be a resilient boy.
But it wasn't until after the chair incident at the defendant's rodeo that changed, correct?
Well, yes, sir. Now I know that he's no longer competing, but that's not the extent of my knowledge.
Thank you, Ms. Jones. I have no further questions, Your Honor.
Thank you. Any redirect?
No redirect, Your Honor.
All right. Thank you, Ms. Jones. You may step down. Is defense ready to call their next witness?
Yes, Your Honor. We called Dr. Daniel Boone to the stand.
Dr. Boone, you take the stand.
And before I begin my direct examination, is it okay for me and my co-counsel to set up some enlargements to use later on?
You may.
Would you please tell this jury your name?
I'm Dr. Daniel Boone.
What kind of doctor are you?
I'm a neurosurgeon.
What does a neurosurgeon do?
We study and operate on the brain, and we also diagnose and treat disorders in the nervous system.
How long have you worked as a neurosurgeon?
Over 20 years now.
Do you have any specific areas of expertise within the field of neurosurgery?
I do. I specialize in traumatic brain injuries, most often dealing with sports-related injuries.
Have you ever been published?
I have been published. I've been published in 5 medical journal articles, and I've written 5 textbook chapters, all concerning traumatic brain injuries.
Dr. Boone, have you ever testified in court before?
I have, 15 times.
Your Honor, at this time, we tender Dr. Boone as an expert in the field of neurology.
No objections, Your Honor.
Thank you. Dr. Boone will be an expert in the field of neurology. Thank you.
Dr. Boone, I'd like to talk a little bit about today's case. How did you get involved?
I was asked to medically evaluate Lee Jasper's injuries and then determine the primary cause of her neurological symptoms.
Did you reach a conclusion?
I did.
What materials did you review to reach this conclusion?
I reviewed all of Lee Jasper's medical records. I personally reviewed her neurological symptoms. I looked through all the witness statements, all exhibits, and then referenced some extra medical literature.
And did you have sufficient facts and data to reach this conclusion?
I did.
Was your conclusion the product of principles that were both reliable and reliably applied in today's case?
It was.
And did you reach this conclusion to a reasonable degree of professional certainty?
Absolutely.
Dr. Boone, what did you conclude?
My conclusion was that Lee Jasper's neurological symptoms were caused by the injury from July 18th, 2024. It could not have been the August 24th, 2024 injury.
Now, before we go any further about your conclusion, I want this jury to get some general information. How does a traumatic brain injury occur?
Oh, you see, the brain sits in the skull in what we call cerebrospinal fluid. This actually cushions the brain from the hard surface of the skull as well as suspends it in the skull. And then when the head gets hit hard enough, this can actually push the brain through the cerebrospinal fluid, and then it hits the hard surface of the skull. And this causes structural damage to the brain itself, and that's when these neurological symptoms start appearing.
What kind of symptoms?
These can be mild and temporary, such as dizziness or headaches, to more moderate, such as memory loss or vision issues, to very severe and long-term, such as vocal disorders or even paralysis.
Dr. Boone, if someone suffers a traumatic brain injury, how important is it that they receive immediate medical attention?
Absolutely critical.
Why?
Here's how I explain to patients. Let's say you're walking around your house and you're looking at the foundation of your home and you notice a couple cracks in the foundation of your home. And then you move on. You ignore it. You think it's nothing to worry about. Let's say water gets into these cracks. The water freezes. The cracks widen. And all the while, your house is putting weight on the foundation of your home. And at some point, it collapses. It's completely ruined beyond repair. And your brain is a lot like that. It's the foundation of your entire being. And seeking treatment early on after an injury is like patching the cracks in the foundation as soon as you see it. It can prevent a minor injury from becoming long-term or life-threatening.
In today's case, did Lee Jasper suffer an injury that went untreated?
Yes, she did.
Would you tell us about that?
Lee Jasper was thrown from a bull on July 18th, 2024, and her head hit a metal gate. This knocked her unconscious, and she didn't report any other instance of being knocked unconscious prior to this.
Why is that loss of consciousness significant?
Well, loss of consciousness is a hallmark indicator of a traumatic brain injury. If you get hit hard enough to lose consciousness, you absolutely cannot go without seeking immediate medical treatment. Otherwise, you run a major risk of a minor injury becoming long-term and life-threatening.
Did Lee Jasper ever receive medical treatment for this injury?
Yes and no. Yes, she did end up going to a medical walk-in clinic a month later, but then while at the clinic, she refused the necessary care, declined the medical personnel's advice to get a CT scan, and left the clinic.
Did you review the record from this walk-in clinic?
I did.
Your Honor, may Dr. Boone join me in the well?
He may.
Now, Dr. Boone, I'm going to show you enlargements of Exhibit F over here and Exhibit G over here. First, would you identify both of these exhibits just so the jury can get a clearer understanding of what's going on?
Absolutely. Over here is Exhibit F. This is the medical report for August 17th, 2024, after that July 18th injury. This is the medical record from August 25th, 2024, following that August 24th injury.
Now, you said after Lee Jasper's first injury, he refused necessary medical care. Could you tell us what you were talking about?
Absolutely, again. Let's step over here. You can see here the symptoms that Lee Jasper reported after medical walk-in clinic. And then because of these symptoms, it says in the report, based on these symptoms, that medical personnel recommended that Lee Jasper get a CT scan just to rule out any other injuries. But then Lee Jasper actually declined this CT scan and left against that medical advice.
Dr. Boone, why is that significant?
When it comes to traumatic brain injuries, the worst thing you can be is uninformed. And Lee Jasper was uninformed because she declined that CT scan. Let's say she had gotten that CT scan. What that CT scan may have shown is that Lee Jasper may have had a prolonged inflammatory response, or an injury that's worsened over time because it's been left untreated. Now, we don't have this CT scan because she refused it, but what we do have are her symptoms, and these symptoms do show signs of a prolonged inflammatory response.
Would you explain what you mean by a prolonged inflammatory response?
Absolutely. It might help if I draw it for you with normal brain. I'm sorry, I'm not very good at drawing. This is what a brain basically looks like. I will not show you my hand. Don't. Where was I? Yes, there are certain areas of the brain that are responsible for different tasks. In this instance, language and vocal coordination. These are called the language centers. They're located about these areas. Let's say these areas may get damaged, and they're left untreated. Treatment would simply be rescue. strenuous activities, let's say that treatment is ignored, these injuries are going to worsen over time, and that's what creates this prolonged inflammatory response.
Dr. Boone, how does that tie into today's case?
We know that Lee Jasper began showing signs of foreign accent syndrome. And she also reported a couple other lasting cognitive issues. There's no immediate onset of these symptoms, nor we expect an immediate onset of these symptoms, because they're all symptoms of a prolonged inflammatory response.
Now, Dr. Boone, just to be clear, is it possible for someone to develop foreign accent syndrome from just one head injury?
It is very unlikely, and when it does happen, when it does occur from one injury, it's easily detectable.
How so?
Well, we would expect to see significant swelling or bleeding to the left hemisphere of the brain, where those language centers are located.
And looking at today's case in Exhibit G, what does that tell you?
Well, first of all, in this after the second injury on August 24th at the walking clinic on August 25th, a CT scan, Lee Jasper actually did get this CT scan. And if you look here, this CT scan showed no cerebral edema or hemorrhage, not for swelling or bleeding.
Dr. Boone, taken together, what does that tell you about Lee Jasper's lasting symptoms, such as foreign accent syndrome?
It means that the July 18th injury was either the primary cause of her symptoms or was the sole cause. Because there was no swelling or bleeding in the left hemisphere of the brain, it could not have been that August 24th injury.
Thank you, Dr. Boone. No further questions, and you may take your seat.
Oh, you can leave those up, actually.
Okay.
Cross?
Yes, John. Good evening, Dr. Boone.
Good evening.
Before you moved to Salem, your job was the Director of Neurotrauma Services at St. Luke's Regional Medical Center.
Yes,
Right.
it was. Yes, sir.
You were fired from that job.
Objection, Your Honor, to improper character evidence.
Response, Your Honor?
You may.
This is an exception to character evidence under Rule 608 because impropriety is the crime for, or is the action for which he was fired for, which is an act of dishonesty.
Now, Your Honor, they're using this testimony to attack his credibility. And under Rule 608 and 609, there's only two reasons that you can attack credibility: prior dishonesty or untruthfulness, or prior convictions. Now, we all agree that there's no convictions here, but this is not an untruthful act. It actually had nothing to do with truthfulness and untruthfulness, as the witness is going to say that he was fired, or at least he was told that he was fired for giving preferential treatment to some higher-up executives.
Objection's overruled. Thank you.
Dr. Boone, I'll restate my question. You were fired from that job for cause because you had committed an impropriety. That's right?
I was fired for cause, but I never committed any impropriety.
Well, you had the opportunity to challenge your termination. That's right?
I did, but there was no reason for me to. I had lost complete respect for the hospital.
That's right. To be clear, after you were fired for something you disagreed with, you didn't challenge that termination, did you?
No, I didn't. I left the hospital.
Now, you're testifying in court today on behalf of the defendant, Ms. Reese Witherford. That's right?
I'm here today to deliver my professional opinion, yes, sir.
For the defense?
Correct.
And Ms. Witherford's actually a close business associate of yours, isn't she?
She helped me move into the town because that's her business, yes, sir.
And that's right. When you moved to Salem, she actually helped you secure funding for you to build your medical practice. Is that right?
Correct. She was the only one in town with that business, so absolutely I went to her.
Dr. Boone, it's your testimony she was the only one in town with that business?
She's the only one that I knew of.
It's your testimony she's the only one that you knew of with
Correct.
that business?
Correct.
You remember giving a sworn statement before coming to trial?
I do.
You recognize that statement if you saw it in court today?
I would.
Your Honor, I'm showing opposing counsel a copy of the witness statement. May I approach the witness?
You may.
Dr. Boone, that's your sworn statement. That's right?
Yes, sir, it is.
You were under oath when you gave that statement?
I was.
And you were told to include all relevant facts related to this case. That's right?
Yes, sir, I was.
And to be clear, Dr. Boone, nowhere in your sworn statement do you ever mention that the reason you went to Ms. Witherford was because there was no one else in town or that she was the only person you knew of with this business?
Sorry, I'm just reading through it real quick. Yes, I never included that anywhere in here because there was no need to say that she was the only one in town with that business.
Your Honor, permission to approach and retrieve the witness's statement.
You may.
Now, Dr. Boone, I want to talk about those medical records that you discussed on direct examination. You have a copy of Exhibits F and G in front of you?
I do.
Now, if you look at, I just want to talk about what you do and do not dispute in this case. To be clear, you don't dispute that following the chair incident, my client suffered a loss of consciousness. That's right?
Following the August 25th injury? August
The 24th injury, yes.
No, I don't disagree with that.
You also don't dispute that my client suffered a head laceration that required 6 stitches. That's right?
No, I do not.
And that my client suffered a concussion. That's true?
No, I don't dispute that at all.
To be clear, you agree that those injuries were directly caused by the chair incident, not the incident in Wichita. That's right?
The laceration, the loss of consciousness, and what was the last one?
A concussion.
Correct.
Now, Dr. Boone, let's talk about some of the symptoms that the plaintiff is experiencing now. You agree that the plaintiff is now experiencing short-term memory deficits?
I believe that's correct.
Episodes of nausea?
The nausea is not reported at all in any of the medical records.
To be clear, Dr. Boone, you reviewed all statements and exhibits related to this case?
I did, and nausea is included in some of those statements, but it's never reported in any medical record.
Dr. Boone, you don't dispute that the plaintiff suffers from episodes of nausea. That's right?
No, I don't, based on the witness statements.
And again, the plaintiff is also suffering from visual disturbances. That's right?
I believe so. Yes, sir.
And finally, the plaintiff is now suffering from a foreign accent syndrome, and you don't dispute that. That's right?
No, sir. That is correct.
It's my understanding of your conclusion that you think that the plaintiff's symptoms emerged because of an incident that predates the chair incident. That's right?
Yes, sir. Absolutely.
So if you look at Exhibit F, the record of the plaintiff's symptoms before the chair incident.
Yes, sir.
Nowhere in Exhibit F ever mentions the plaintiff experiencing a foreign accent syndrome before the chair incident. That's right?
No, it doesn't, and I explained that in my direct, sir.
If you look at Exhibit F under complaints, it says patient, that's Lee Jasper, denies nausea, blurred vision, and memory loss. I read that correctly?
Yes, you did.
So you have no medical record, no evidence from any medical professional that the plaintiff ever experienced nausea, blurred vision, or memory loss until after he was hit in the head with a chair.
That's correct.
Thank you, Dr. Boone. I have no further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
And thank you, Dr. Boone. You may step down.
Sure.
Is defense ready for their last witness?
The defense calls Reese Witherfork to the stand.
Ms. Witherfork, you may take the stand.
Please tell us your name.
My name is Reese Witherfork.
Ms. Witherfork, have you been sitting in this trial listening to this plaintiff accuse you of being negligent in your operation of the Jinx County Fair?
Yes, ma'am, I have.
Were you?
No, I was not negligent.
Could you have ever...
Objection. Your Honor, the defendant cannot testify to whether or not she was negligent. That's a legal term. It can only be determined by the jury after finding sufficient facts and data.
Your Honor, may I respond?
You may.
Now, in this jurisdiction, we have a rule, it's Rule 704, which specifically states that, I'll read it exactly for the court here, testimony in the form of an opinion or inference otherwise admissible is not objectionable because it embraces an ultimate issue to be decided by the trier of fact. Now, Mr. Royer is arguing that this evidence is inadmissible and therefore objectionable because it embraces that issue. Rule 704 specifically gives us a precaution for that kind of objection, tells us it cannot be made, therefore this evidence is admissible.
Any response?
Yes, Your Honor. Rule 704, testimony on an ultimate issue, does not specifically admit the witness to testifying as to whether or not she acted negligent. There's a lot of evidence that has to be presented for that. Your Honor, there's been no foundation laid for this opinion on that ultimate issue. And Your Honor, if that foundation not be laid, this is an improper legal opinion that she cannot give.
Your Honor, may I have a response?
I'm ready to rule. The objection will be sustained. Thank you.
Ms. Witherfork, could you have ever possibly foreseen that one of your rodeo attendees would have hauled a chair from the stands into the ring at one of your bull riders?
No, ma'am, I could have never foreseen that.
All right, now before we talk about what happened on August 24th, I'd like to let this jury get to know you a little bit more. Did you grow up here?
Yes, right here in Salem, over in the Cassville neighborhood by the Dollar General. Not the big Dollar General.
What do you do for a living here in Salem?
Well, I own and operate multiple businesses here in town.
What kind of businesses?
I own 5 pool halls, a sort of themed restaurant, but my flagship is the Jinx County Fair Rodeo.
How did you get started running all those businesses?
I've been an entrepreneur my whole life. I opened my first taco truck before I was even out of high school, bringing to football game nights, and usually end up drawing a bigger crowd than the team. Though I will say the Salem Banshee Possums are never known for their football prowess. Well, anyways, I started my first pool hall about 20 years ago now, and it was basically just that, a couple of pool tables and what was basically a hallway, and it really took off. Kept going from there.
You said your flagship was the annual Jinx County Fair Rodeo. Can you tell us a little bit more about that?
Sure, it's a week-long national event that happens every August here in Salem. We host the most famous cowboy personalities and western bull rider types. It's a ton of fun, but it requires an enormous amount of planning.
How do you go about planning for your rodeo?
I start the process about 11 months in advance, almost a year.
Doing what?
Securing the permits, approving vendors, booking the talent, purchasing equipment, really everything that goes into planning a large-scale event.
Now, since the plaintiff has not called anyone in today to talk about how security would work at a large-scale rodeo event, I figured I'd ask you about your personal experience in managing security. How do you do that?
Yes, ma'am. My team and I, we searched far and wide about 3 years ago for our head of security, Mr. Jordan Diamond. He has a degree in security management. He used to be the head of a security team at the biggest theme park in the world. He's been working for me the last 3 years, and it's been great.
What sort of things is your head of security responsible for?
Mr. Jordan Diamond is in charge of securing everybody, making sure everybody's safe. That's patrolling the crowds, making sure everybody's following the right safety protocols. He specifically introduced this incident reporting system. That lets us review any hiccups we might have had and lets us do better for the next years.
Now, before August 24th, had there ever been a physical fight at your rodeo?
Yes, ma'am. About 3 years ago, a couple of guys got into it while waiting in line for a pretzel.
What did you and your security team do about that?
Well, they immediately intervened, ma'am. They went straight to the argument, de-escalated that situation, and banned them both from re-entry to my rodeo.
All right, so after that incident, and still before August 24th, had there ever been another physical fight at your rodeo?
No, ma'am, none whatsoever.
All right, now I do want to talk a little bit about the night of August 24th. Did you know that a man named Wiley Smith would be attending your rodeo that day?
I did figure he'd be there. He attends every year.
What did you know about Wiley Smith at the time?
He's a local broker in the livestock trade. He's got a bit of a reputation for being sort of a hothead around town. He's actually escorted out of one of my pool halls for yelling at another customer.
Were you aware of that incident prior to August 24th?
Yes, ma'am.
Ms. Witherfork, if you were aware of him being escorted out of your pool hall, why didn't you ban him from your rodeo?
Look, Wiley Smith has been to every single one of my rodeos, and he's never once caused a problem at any of them.
Really, it's been the opposite. He's usually there for business, doing livestock trades, and I just didn't think it was right to tell this guy, hey, you're banned from my rodeo for the sole reason that you and some other guy yelled at each other in a sports bar. It's just not reasonable.
Was your security team in place at the rodeo on August 24th?
Yes, absolutely.
And were you present when the chair was thrown?
Yes, ma'am.
Did you ever come to learn, Ms. Witherford, how that chair was thrown?
I later learned that Wiley Smith had gotten into it with another livestock trader, River Jenkins, and he had attempted to throw a chair at him and missed.
Now, Ms. Witherford, today, have you been listening to this plaintiff second guess your level of security at your rodeo?
Yes, ma'am, I have.
What do you say to that?
On the one hand, I understand Mr. Jasper was hurt, and I'm truly sorry for everything he's had to deal with. Sure, in hindsight, if I had known Mr. Jasper would have been hurt, no question about it, Wiley Smith would have been banned from my rodeo. But on the other hand, I went above and beyond to ensure that my security team was well managed and well trained. And I wish that meant we could just prevent every accident from happening, but it just doesn't. And that doesn't make me unreasonable.
Objection.
Thank you, Ms. Witherford.
Your Honor, once again, this is testimony that she is not reasonable, which is legal, Your Honor, and the witness cannot testify to this. That's for the jury to decide.
Your Honor, may I have a response?
You may.
Now, the witness is allowed under Rule 701 to give rationally based perceptions. Part of rationally based perceptions would be those based upon the witness's own experience. The witness is allowed to testify as to her own experience and her own thoughts. And if Ms. Witherford personally experienced believing that she was not reasonable, well, she hasn't concluded that that was in any way legal. She hasn't tried to implicate that from that the jury should, well, take that to mean anything particularly legal. Ms. Witherford has simply explained that she personally was not reasonable from her own experience, or pardon me, was not unreasonable from her own experience in conducting her rodeo.
All right, any response?
Yes, Your Honor. I would like to add that the term reasonableness is inherently a legal term. In the applicable law or the jury instructions that Your Honor wrote before trial, it specifically references the word reasonableness, and I'm sure the witness is testifying this to specifically reference that word so that when the jury deliberates, they find that she was not unreasonable.
Your Honor, may I have a response?
You may not. Thank you very much. Your objection's overruled.
Yes, Your Honor.
Now, Ms. Witherford, I'm going to ask you that last question one more time. What do you have to say to the plaintiff second-guessing your security at your rodeo?
Like I said, ma'am, I understand the concern here, but I did my absolute best to have ample security at my rodeo, followed all protocols anywhere, and I do believe that I acted reasonably.
Thank you, Ms. Witherford. I have no further questions.
Thank you. Cross?
Yes, Your Honor, and before I begin, permission to set up an easel in the wall?
You may.
May I proceed, Your Honor?
You may.
Ma'am, I want to begin with something that you mentioned on your direct examination. You said that Jordan Diamond has a degree in security. Did I hear that correctly?
I do believe Jordan Diamond is well educated in security. That's my understanding.
Ma'am, you testified that he had a degree. That's right?
That's to my knowledge what I heard from Jordan Diamond, but what I can say 100% for sure is that he's well educated, as his experience in being the head of security at one of the largest theme parks in the world.
You remember giving a sworn statement before coming to trial today?
Yes, sir.
You'd recognize it if you saw it?
Yes, absolutely.
Your Honor, permission to approach opposing counsel?
You may.
Permission to approach the witness?
You may.
Ms. Witherford, this is your sworn statement, that's correct?
Yes, it is.
That's your name at the top?
Yes, absolutely.
You were under oath when you wrote this statement?
Yes, ma'am, to tell nothing but the truth and the whole truth.
That's right, as well as all facts that are pertinent to this case. That's right?
Yes, sir.
But nowhere in this statement do you ever mention that Jordan Diamond has a degree in security?
No, sir, I don't. I didn't think it was necessary to include the full background of my security members, other than to the extent that he is well experienced, well educated. And if my introducing the new fact of his degree is troublesome, I'm willing to redact anything about that as long as we understand he's well educated in the subject.
Just to be clear, you thought it was necessary to tell this jury that you hired the best security in all of the United States, but you found it not necessary to include that he has education in that line of work?
Yes, sir. The title of best in the United States, I would hope would imply so.
I want to talk about the two men that fought at your rodeo. Coyote Smith and River Jenkins are two of your rodeo's most loyal attendees. That's right?
Yes, sir. They attend almost every day of every year.
You believed it was highly likely that both men attended every night of your 2024 rodeo.
Yes, sir. I did believe they would.
And you were aware that these two men were involved in a dispute over a bull named Cap?
I had read something about that in what is basically our town's gossip column, the Salem Tribune. I love to stay up to date. And something about a lawsuit, something about a bull, yes, sir.
Right, and Cap the Bull, to your knowledge, is the most notorious bull in all of Salem. In fact, in all of the amateur bull riding circuit. That's right?
Yes, we were quite excited to host him at my rodeo.
It's also the toughest bull in all of the circuit.
Yes, I've never ridden him myself, but that's what they say.
And you heard the testimony of Mr. Hamilton earlier?
Yes, sir.
You heard Mr. Hamilton say that Lee Jasper stayed on that bull for 9 seconds?
Yes, sir, I was there. It was quite the feat.
I want to talk more about this bull. Now, it wasn't just important to Coyote Smith and River Jenkins. It was important to you. That's true?
Yes, sir. Important to me in that it would make the members who were attending very happy to see Cap at my rodeo.
Well, that's because Cap the Bull was your 2024 rodeo's biggest attraction. That's right?
Yes, he was sort of the headliner among dozens of other attractions that we love to host at my rodeo.
By biggest attraction, you mean to say that it attracted the most people to your rodeo. That's true?
That was the hope, sir.
And you would agree that it was your belief that if you barred Coyote Smith from attending your rodeo, that would jeopardize Cap's appearance.
Yes, sir. I didn't think the bull would appear without its owner.
And you didn't want to jeopardize your biggest attraction?
No, sir. I just wanted everybody to see him. They were real excited. The community was all riled up about seeing Cap, you know.
And you would agree with me that it's logical as a business owner that fewer people at your rodeo means less money.
Yes, sir. I guess you could say that.
And you were planning on using the funds that you secured from your last year's rodeo to expand.
Objection, relevance.
Any response?
Yes, Your Honor, this is very relevant. What the plaintiff is trying to prove in today's trial is that the defendant had a greed for profit that she placed over the need for public safety, which goes directly to her reasonableness in the decision she made not to ban Coyote Smith from her rodeo. This line of questioning is directly about the bull that Coyote Smith would have, by banning Coyote Smith would have jeopardized its appearance, and therefore she would have made less money.
Your Honor, may I respond?
You may.
Now, in this case, what I'm specifically objecting to is not the line of questioning itself. I agree that the jeopardization of the bull and what profit she might have lost on that would be relevant. What I'm specifically objecting to is counsel's question about what she plans to do with that profit. I believe it is irrelevant to this case and to any of the elements of negligence what my client personally planned to do with any profit that would have gone to herself. What opposing counsel needs to establish is that she profited. I would agree, that is relevant. But as to her specific personal plans, that is irrelevant and is not going to make a fact of consequence more or less likely.
Objections overruled. You may continue.
Yes, Your Honor. You planned on using the money from last year's rodeo to expand to other parts of the state. That's true?
Yes, sir. I'm covered in terms of profits with my other businesses, so I like to take the revenue from this event to invest back into it, make it bigger so more people can attend and enjoy events like seeing Cap.
Wait a minute, Ms. Witherford, is it your testimony that you're covered with profits from your other businesses?
Yes, sir. I would say I own multiple businesses, which obviously generate a profit. And I would say that I specifically invest back into the rodeo with that kind of profit.
You still have your statement in front of you?
Yes, sir.
Nowhere in that statement do you ever mention that you can cover the profits with your other businesses?
Cover my own profits, sir? I think I'm confused on this question.
I'll re-ask. Nowhere in your statement do you ever say that you can cover the expenses of expanding your rodeo with your other business's profit?
Oh, sir, I think we have a misunderstanding here. I'm saying myself, as in paying for my mortgage, my taxes, that sort of thing. I am covered when it comes to owning multiple businesses, so I don't necessarily take the revenue generated from my rodeo and give it to myself. I like to invest it back in, which is exactly what you were suggesting. We're in agreement here, sir.
Just to make it clear for the jury, because I think it's a little confusing, you were planning on using the revenue from last year's rodeo, that revenue, to expand to other parts of the state. That
Yes,
is correct.
sir. We are in absolute agreement on that.
Now, just to be clear, I want to talk about exactly what you knew. You read the newspaper cover to cover every single morning, that's true?
Yes, sir, absolutely. I love to stay up to date as a local business owner.
You read a newspaper article about the dispute between Coyote Smith and River Jenkins?
Yes, sir.
And you'd recognize it if you saw it?
I do believe I would.
Your Honor, I'm showing opposing counsel, or permission to show opposing counsel Exhibit M.
You may.
Permission to approach the witness?
You may.
Ms. Witherfork, Exhibit M is the article that you read about the dispute between Coyote Smith and River Jenkins?
Yes, sir.
Your Honor, the plaintiff offers Exhibit M into evidence.
Exhibit M will be admitted.
Permission to display an enlargement of Exhibit M?
You may.
Now, ma'am, in this article it talks about how Coyote Smith won Cap the Bull in a card game, but River Jenkins claims that Coyote Smith cheated. That's right?
Yes, sir. This article is the extent of my knowledge on anything regarding this situation.
Now, I would like to direct you to the first column, third paragraph, and if you could read silently as I read aloud.
Yes, sir.
It says, Jenkins and Coyote have been bickering the entire night before that fateful game. It's no secret those two don't get along. I read that correctly?
Yes, sir.
If I could direct you to the second column, the first full paragraph, and read silently as I read aloud, it says, Coyote knows what Jenkins is saying, and Coyote doesn't let that stuff go. Jenkins ought to watch out. I read that correctly?
Yes, sir.
Just to be clear, man, that's not the extent of your knowledge that you had on Coyote Smith. You also know that Coyote Smith was kicked out of one of your pool halls for disruptive behavior. That's right?
Yes, sir. I do believe him and another customer were yelling at each other.
And you read a newspaper article about those instances?
Yes, sir.
Your Honor, I'm showing opposing counsel. Permission to show opposing counsel Exhibit I.
You may.
Exhibit L, rather.
Exhibit L.
Permission to post the witness?
You may.
Exhibit L is that article about those pool hall incidents?
Well, sir, it is the first two columns of the article, but I'm sorry to say this is not the full article.
But that is a portion of the article that talks about the pool hall incidents?
It is one piece of it, yes. The very beginning, sort of the introduction.
Yes, Your Honor. Yes, ma'am. With that, Your Honor, the plaintiff offers Exhibit L to evidence.
Your Honor, I have an objection to Rule 106 incompleteness.
Anything else you'd like to say on that before I let him
Yes, Your
respond?
Honor. So what Rule 106 says is that if he is to introduce this writing or recorded statement, that the adverse party may require the introduction at that same time of any other part of that writing or other piece of writing that ought in fairness be considered with it. Now, in this case, Mr. Royer has not introduced the rest of this article. We've heard from the witness herself that this is the first two columns, and if we take a look at this exhibit, does Your Honor have a copy?
I do not have one in front of me.
Would you like me to present one to you?
You may. Thank you.
And as I believe the court now can see, this is the first two columns of a newspaper article with the title showing that it expands early on and with the paper being folded in a way that it expands later on. For that reason, it's incomplete, and I would like to currently require that he introduce the rest of that newspaper article, or it is inadmissible.
Would you like to respond?
Yes, Your Honor, I have two responses. Firstly, under Stipulation 10, this exhibit was created with those exact paragraphs, that exact frame of reference, and was stipulated to be authentic under Exhibit 10 to be introduced at trial. Secondly, Your Honor, Rule 106, I believe it's being slightly mischaracterized by opposing counsel. While it does say that an adverse party may require the introduction of other parts of the writing, it also requires somewhat of a burden of proof from opposing counsel, Your Honor. It requires them to prove that in fairness, meaning to preserve fairness, it has to be considered contemporaneously with the other portion of the article that is pictured in this exhibit. Unless they cannot provide a reason why the other portions of the article have to be shown contemporaneously with this one, in fairness, this article is perfectly admissible.
Your Honor, may I have a response?
Briefly.
Now, Your Honor, Rule 106 refers to the fact that the adverse party may at any time require the introduction of another part of writing. The rule does not imply that we need to bring that before the court. I would also like to clear up a misconception about Stipulation 10. Stipulation 10 states that all exhibits in this case are authentic. It does not state that all exhibits in this case are admissible, nor does it specifically refer to Exhibit L. So though it may be authentic, though it may be what it purports to be, what it purports to be is the first two columns of an incomplete newspaper.
Your Honor, if I may, with that response.
I am prepared to rule. I am sustaining the objection. Without the complete article, it will be not admitted into evidence.
Yes, Your Honor. Now, Ms. Witherford, you were warned personally by a sheriff's deputy of Jinx County that it's only a matter of time before Coyote Smith gets into a physical altercation. That's true?
Yes, Skylar Parker's a good friend of mine, and he did say those words after introducing the evidence that he had gotten into verbal disputes, which is just not the grounds to ban someone from a public event.
Ma'am, you just talked about banning. You could have certainly separated the two. That's right.
Sir, the way my rodeo works is you buy a ticket and you sit where you like.
Well, in purpose of safety, you certainly could have separated them.
In order to go scurry around my rodeo and find them and tell them to sit in different spots, I don't know what time they're arriving, I don't know who they're coming with. It would be required to ban somebody from the event instead of just separating them.
Ma'am, in the interest of time, my final question is, are you testifying to this jury that you didn't do anything to stop him from fighting because it was too difficult to find them?
No, that is not my testimony today.
No further questions, Your Honor.
Thank you. Any redirect?
No redirect, Your Honor.
All right. Thank you, ma'am. You may step down. You are excused.
At this time, the defense rests.
All right. Wonderful. Are we ready for closing arguments?
Yes, Your Honor, the plaintiff is ready for closing arguments.
You may proceed.
Yes, Your Honor. And before I begin, permission to reserve up to 1 minute of my remaining time for rebuttal.
You may.
And if I may, Your Honor, I'm going to take down the demonstrative in the well before I begin.
You may.
May I proceed, Your Honor?
You may.
Why? Why did the defendant shrug her shoulders and laugh in the face of Deputy Parker when she was warned that there was going to be a fight at her rodeo? Why did the defendant not want to ban her rodeo's biggest attraction? One answer. It's money. Because the defendant put the greed for profit over the need for public safety. As the plaintiff today, it was our burden to prove two things by preponderance of the evidence. Firstly, we had to prove that the defendant was negligent by breaching her ordinary duty of care at the rodeo and allowing Coyote Smith to remain at the rodeo after being warned by a sheriff's deputy that a fight was going to happen. And secondly, we had to prove that that negligence resulted in the plaintiff's injuries. As Mr. Magell said in opening statements, we have met this burden by proving three facts. Fact number one, the defendant was warned that there was going to be a fight. Fact number two, the defendant ignored this warning for money. In fact, number 3, the defendant's negligence caused the plaintiff's injuries. I'll take each of these one at a time, starting with fact number 1, that the defendant was warned. You heard what Sheriff Deputy Parker told you when he saw Coyote Smith and River Jenkins in the stands at the rodeo. He sprinted immediately to the defendant and told him everything, told her rather. The defendant knew how these two men felt about each other. The defendant knew that Coyote was a ticking time bomb. The defendant knew that it was only a matter of time before a fight broke out at her rodeo. And that brings me to fact number 2. She ignored that warning for profit. Members of the jury, when she was warned by Deputy Parker that a fight was going to happen, she shrugged her shoulders and laughed. She laughed, members of the jury. A fact that she didn't even try to dispute on the witness stand. She said, if I kept out everyone who might start a fight, I'd lose too much money. Deputy Parker didn't say that there might be a fight. He said that there would be a fight. And it's unreasonable to completely disregard the warning from a sheriff's deputy regarding public safety. And that brings me to fact number 3. Causation. We've already proven that it was the defendant's negligence that allowed Coyote Smith to be at the rodeo in the first place. But it's been undisputed throughout the entire trial that my client suffered unconsciousness, a laceration to the head requiring 6 stitches, as well as other injuries that occurred only after the chair incident. Dr. Carton tied it together beautifully, that all of these debilitating mental conditions are solely a result of the chair that was thrown at Ms. Witherforth's rodeo. Members of the jury, all of this is why we ask you to find the defendant liable for negligence. Because she put the greed for profit over the need for public safety, resulting in Mr. Jasper's injuries. Thank you.
Right. You may proceed.
Members of the jury, I want you to imagine for a second that you're buying a car. The salesman has just about sold you on one, and he promised you that it runs fine. Brand new tires, and it's just had a tune-up. So proudly, you take it home. But the next morning, as you back it out of the driveway, you see a puddle of motor oil there. Next, the AC goes out, the power steering locks up, and the engine is overheating. Members of the jury, it shouldn't take you long to realize that that salesman sold you a lemon. And he did that by telling you half of the story. Because that salesman knew that if he told you the car's whole story, he would have lost the sale. Now, that's what this plaintiff is doing in today's case. They're trying to sell you a car while keeping their fingers crossed behind their back and hoping that you won't look under the hood. Because it's easy to tell half the story when the whole story will cost you. Now, before I go any further, I want to make one thing clear. This is their lawsuit. It's been on their table today to prove by the greater weight of the evidence that Reese Witherfork was negligent. But if you believe that Reese Witherfork acted reasonably, that Lee Jasper acted unreasonably, that Lee Jasper's unreasonableness led to his injuries, or if you think any of these 3 things are a complete toss-up, well, you can't find her liable. So first, was Reese Witherfork negligent? Today, the plaintiff's entire case hinges on you believing that she was unreasonable for letting Wiley Smith into her rodeo. But you heard their witness, Deputy Parker, get up on the stand today and say, I don't know of a single other violent encounter. Wiley Smith wasn't violent before the rodeo. Sure, It would be one thing if this guy had just gotten out of prison for murder, or if before the rodeo he was swinging a bat at windshields. But that's not the case. The best they've got is a loudmouth trash talker. That's it. So I want you to look at the big picture here. What they're saying is that if there's some guy out there running his mouth at bars or restaurants, then my goodness, he must be banned from every public event. Members of the jury, that's just as absurd as it sounds, but that's their case. For that reason alone, they failed to prove their burden, but there's more. We know that Lee Jasper suffered a nearly identical head injury before the rodeo. You notice that Mr. Royer didn't say anything about that in his closing argument because once again, they're only telling you half of the whole story. Because the whole story is that after Lee Jasper hit his head, he refused medical care for a whole month. And after finally being convinced to go to the walk-in clinic, he walked right back out with no CT scan. Members of the jury, that's not reasonable care. That's not even care. Which brings us to our final question. What caused Lee Jasper's lasting symptoms like foreign accent syndrome? It was their job to prove that it was August 24th, but they couldn't do it. Because there's a problem that even their own neurologist can't deny. For foreign accent syndrome to appear from just one head injury, there must be swelling or hemorrhaging in the brain. But the second CT scan after the rodeo, the only CT scan ever taken, showed neither. And even if we put that aside, we're talking about a professional bull rider, for goodness sake. Who knows how many other injuries that Lee Jasper sustained that may have led to this foreign accent syndrome? I mean, it's the only sport where your opponent is literally trying to kill you. It was on them today to prove that August 24th caused that foreign accent syndrome, and they couldn't do it. They couldn't even do it when they told you half the story. Because they knew the whole story would have cost Lee Jasper this lawsuit. Reese Witherfork was not negligent. Find her not liable. Thank you.
Any rebuttal?
Yes, Your Honor. Before I begin, may I ask how much time I have remaining for rebuttal?
The plaintiff has 55 seconds.
Thank you.
May I proceed, Your Honor?
You may.
It's undisputed that my client retained a laceration to the head requiring 6 stitches solely as a result of being hit by the metal folding chair, which means we only have to prove negligence. They tried to tell you it's unreasonable to assume that she would have banned Coyote Smith or not let him into the rodeo, but members of the jury, she could have separated the two at the rodeo. She could have put more security by them at the rodeo. The only thing that she could not have done, the worst option, is exactly what she did, which is nothing. You see, they're not telling you the whole story. Despite what opposing counsel says, they're hiding the truth from you. They disregarded that Mr. Hamilton told you that there's been physical fights involving Coyote Smith all the time. This entire trial is the defendant hiding her profit motive. And they said it best. It's better to tell half the story when the full story hurts you. And you're going to find that it hurts the defendant. Thank you.
All right, thank you very much. The court is going to take a brief recess.
All right.
I'm going to say one more thing. You all are doing things that I could never have done as a high school student, and so my hat goes off to you all, and I'm just truly impressed. And now I think I'm supposed to announce the winner. The winner of tonight's competition is the plaintiff, Montgomery Bell.